1 year ago, a judicial ruling was made that turned the contentious 30-meter telescope conflict on Mauna Kea upside down. The 30-meter telescope will be one of the most powerful telescopes in the history of the world, enabling astronomers to peer back in time to the very edge of the observable universe. The University of California and Caltech are behind the project, as well as international partners in Canada, Japan, China, and India. The observatory has the full support of the University of Hawaii, which oversees the 525-acre astronomy precinct on the summit of Mauna Kea, part of a larger 11,000-acre science reserve that UH has leased from the Department of Land and Natural Resources since 1968. In December 2015, the Hawaii Supreme Court halted the construction and vacated the permit. The High Court found that the state did not follow proper procedure in awarding the permit to the university.
There are certain fundamentals of just procedure which are the same for every type of tribunal and every type of proceeding. A fair trial in a fair tribunal is a basic requirement of due process. Justice must not only be done, but manifestly be seen to be done.
The attorney for the appellants, Richard Werdeman, was hailed as a legal hero by opponents of the TMT project.
One of the most significant and important cultural sites in Hawaii. It is the source of the genealogical story for Hawaiian people, for Hawaiian society, for Hawaiian culture. This is the source. Mauna Kea has really become an absolute mess. It's there's been significant adverse impact that's been found. We have what is essentially an industrial center up on top of the conservation district on the summit of Mauna Kea.
The matter was remanded back to the Land Board, which opted to try again with another contested case hearing.
So I welcome you all to the hearing we're having today. The hearing involves only the motions to intervene.
Retired Judge Ricky Mayamano was assigned as the hearing officer.
You didn't have a chance to
move out to the front of the facility and on the area.
But it's hard to tell what will come.
Yeah,
in the following days.
The original hui of petitioners who were successful at the Supreme Court are participating in the second contested case as well.
And right now, that's all that matters.
Werdeman was back on the case, raising new concerns with the remanded matter during pre-conference hearings.
When an agency doesn't promulgate rules, or when it doesn't follow its rules, then that agency, under case law, is acting arbitrarily and capriciously.
First, Werdeman tried to have Amano removed as hearing officer, saying there was a conflict of interest due to her support of the Imiloa Astronomy Center, a university-run learning facility devoted to astronomy and Hawaiian culture.
It's a problem, and it needs to be addressed.
In another motion, Werdeman objected to the state's attorneys representing Amano and the Board of Land and Natural Resources in the case.
Mr. Weinhoff and Ms. Chino were actively taking an adversarial role on the issues that are before you in this case. So these counsel, including one of my clients, and I'll represent to this hearing officer, one of my clients was arrested, a member of the Flores case Ohana, after Mr. Chin went before the Land Board and made this big presentation about emergency rules in dealing with protectors up on Mauna Kea and how to get them out of the way. And this appears to be this home run that they found, that they were talking about. This appears that this coming up with this idea of emergency rules was this home run that all of these parties were talking about on how to take out some of these parties and my client from these proceedings. It's really disingenuous to for the other parties to somehow think that it's just something that we can just simply sweep under the rug. I think that the only proper recourse is for disqualification. If we're going to give the Supreme Court's decision any consideration whatsoever.
Weren't they acting as counsels to clients like the Department of Labor or BLNR? They themselves were not the adversaries.
They were certainly, and during the appellate process, they were advocating for a position and trying to find out how to get people arrested and prosecuted, and they engaged in that.
In fact, Werdeman wanted to see the entire application for the Conservation District use permit thrown out due to changes that have occurred since the original application was filed years ago.
TMT stated on the record that these are two separate entities. You know, down the road, I mean, hypothetically, I mean, if a CDUP was issued, who would it be issued to? The only remedy is to strike the application.
On the eve of the start of the actual hearing in October, a surprise, Werdeman withdrew. The original hui of petitioners went pro se without a lawyer representing themselves, with the exception of KAHEA, the Hawaiian Environmental Alliance, which retained their own attorney representation.
It might be appropriate to find out what your thoughts are, because if it's impacted because you are now representing yourself, I need to hear that.
Okay, so the impact is not necessarily representing myself. The impact is how this is being scheduled. There are still motions outstanding, in particular the motion to strike the Conservation District use application, HA 3568, dated September 2nd, 2010, and or motion for summary judgment, document number 94. In addition to that, we also have a motion that's still out, that hasn't been acted upon. That's motion to disqualify BNR's and hearing officers' counsel. That's document number 95. These were filed nearly 3 months ago, on July 18th. So from tomorrow, it would be 3 months. There's been no response or no motions filed on behalf of these.
Werdeman's motions were eventually denied by the Land Board. The next time anyone heard from Werdeman was when he filed an appeal to the Hawaii Supreme Court challenging the Land Board's dismissal of his concerns.
That since we've been in recess, last week, I've forgotten the date, I think it was Monday, and that would be November 7th. I believe Mr. Werdeman, on behalf of Mauna Kea Anaina Ho plaintiffs or petitioners, and also KAHEA, filed a notice of appeal to the Supreme Court. I understand also that Mr. Sinkin, on behalf of Lono, Temple of Lono, filed a similar notice of appeal. I'm not sure what the details are. I'm aware that there's been a motion to dismiss those the Mauna Kea Anaina Ho appeal that was filed by the state, I think, on November 10th, and a similar motion filed by University on Monday the 14th, and a joinder filed by TIO on the 14th. This is all in the Supreme Court, not in this hearing right now. And then I think Mr. Sinkin's notice may have come in yesterday, so I don't know if there's anything filed in relation to that, other than that notice. Yeah. So I don't know if there's going to be any. That's all in the Supreme Court. I don't have anything to do with that. I didn't even really read the matters. I have a lot to read with the case, and I try to stay on top of this case. It's kind of a handful. But as I'm sure you all know, so my point is that I have researched and I've looked the best I can to see whether or not it impacts us going forward with this contested case hearing. To my knowledge, it does not. I don't see a stay. I don't see a court order. I don't see any authority that would stop us, and my intention is to go forward. But I'd like to give each of you an opportunity, because this is a big thing, to speak to that issue, and I'll go down the row. Mr. Louis Kwan?
Yes, Judge. Under HRS Chapter 91, there is no automatic stay on the filing of a notice of appeal, an agency appeal under 9114. It's in our motion to dismiss the notice of appeal filed by the petitioners that we filed yesterday. We actually set out the statute as well as the law in that matter.
Okay, thank you.
Challenging procedure may be the only chance 30-meter telescope opponents have of stopping the project. In a 3-2 ruling issued in October, the same Supreme Court sided with developers of the Daniel K. Inouye Solar Telescope on Maui's Haleakala. The High Court concluded that the solar observatory was consistent with the purposes of both general subzones and conservation districts. That's thanks in large part to the Hawaii administrative rule that lists, quote, astronomy facilities under an approved management plan as one of the allowable uses under a resource subzone. TMT would fall under the Mauna Kea Comprehensive Management Plan, and therefore a similar ruling might be expected from the Hawaii Supreme Court if the approval of the Mauna Kea permit is appealed again.
Astronomy facilities are an allowed use under the Conservation District rules, and the purpose of the Conservation District is not to stop any development, okay? And you use the words appropriate management of use and use of the resources of the area. And so if those words are in the statute, they're meant to have meaning, okay? And so it doesn't say that there should be nothing built, that this is completely preserved and nothing should be built. It says no. Use appropriate management and use of the resources there. And then he tied the astronomy facilities with the height of the mountain, clear skies, and things of that nature that would be an appropriate use of those resources. So it's not that government cannot allow things to occur in a conservation district. They can, they just have to manage it appropriately.
That is, unless the court finds that the state did not conduct the contested case hearing properly, as it did the first time around.
It's going to be a long and tedious process, but at the same time, it's one that has to be done correctly this time. If you remember, the state Supreme Court brought down a decision that said the contested case hearings must be held in order for a permit to be approved to allow construction for the TMT project by April 2018. And that's what we're hoping for, is that the process will be timely, expedient, but at the same time it will be fair and correct. And then hopefully we'll get the permit which will allow work to start in 2018.